Big news is shaking Nigeria's oil and gas sector. The clash between Dangote Refinery and PENGASSAN, the Petroleum and Natural Gas Senior Staff Association of Nigeria. Hundreds of workers were allegedly sacked, and now PENGASSAN has ordered a halt in gas and crude supply to the refinery. But here's the real issue. Dangote's right to hire and fire versus the workers' right to join a union. Let's break down these legal issues. First, let's talk about Dangote's right. Under Nigerian labor law, an employer has the power to hire and fire. Courts have made it clear. No court can force an unwilling employer to retain a worker. In fact, in the famous case of SPDC versus Olarewaju, 2008 Law Pavilion Electronic Law Report 3046 Supreme Court, the court said exactly that. So yes, Dangote Refinery, like any employer, has the right to restructure, downsize, or even terminate workers. But, and this is important, that power is not absolute. It must follow the law, respect employment contracts, and cannot be discriminatory. Now let's look at the workers' side. Section 40 of the Nigerian Constitution guarantees every citizen the right to freedom of association, and that includes joining trade unions. Nigeria has also signed international conventions that protect workers from being punished for union activity. The law is very clear. You cannot sack workers just because they joined a union. In fact, the National Industrial Court has repeatedly held that union membership is a protected right, and any attempt to victimize workers for exercising that right is unlawful. Naturally, the question then follows. When an organization is not arranged to have its staff join a union, can the organization be compelled to admit its staff to unions? Section 6 of the Labour Act answers this question. It states that no contract shall make it a condition of employment that a worker shall or shall not join a trade union, or shall not relinquish membership of a trade union, or cause the dismissal of or otherwise prejudice a worker by reason of trade union membership, or because of trade union activities outside working hours, or with the consent of the employer within working hours, or by reason of the fact that he has lost or been deprived of membership of a trade union, or has refused or been unable to become, or for any other reason is not a member of a trade union. Upon a joint reading of Article 2 of the International Labour Organization, ILO Convention 87, and Section 9, Sub 6 of the Labour Act, it becomes evident that if the rules governing private refining does not mandate staff to or not to join unions, they cannot be mandated to. It is not clear if the terms in the employment contract between Dangote and his staffs expressly prevents his staffs from joining unions. The contract between Dangote and the sacked staffs should be further reviewed if one is to determine if it truly contains anti-unionism terms. If not, Dangote is free to hire and fire any staff, whether or not they are part of a union. So where is the clash? If Dangote sacked those workers for economic or operational reasons, then the law is on Dangote's side. But if the sackings were because the workers joined PENGASSAN, that is illegal. It is union victimization. The big challenge is proving why the workers were sacked. Employers rarely admit to targeting union members, so the court would look at circumstantial evidence, the timing of the dismissals, the number of union members affected, and any internal document that suggests anti-union motives. Although the law is settled that an employer has an unfettered right to terminate the employee's employment and is not bound to give reasons for terminating the said employment, he may terminate for good or bad reason or for no reason at all. See Zide versus River State Civil Service Commission, 2007 Law Pavilion Electronic Law Report, 3544 Supreme Court. When a reason is provided by the employer, it is not the business of the court to interfere with or probe into the rationality of the reason or the motive for it. A willing employee cannot be forced on an unwilling employer. The onus is on the employees alleging wrongful termination of employment by Dangote. The employees have the onus to prove the wrongful termination by A. Placing before the court the terms and conditions of the contract of employment, and B. Proving in what manner the said terms were breached by the employer. See Okumu Oil Palm Co. Limited versus Ihe 2001 Law Pavilion Electronic Law Report, Supreme Court. It is settled in law on privity of contract that a person is not under any obligation to bear the burden of a contract to which he is not privy, even though the contract is in his favor or for his benefit. Only a person who is party to a contract can sue on it. It is only contracting parties that know what their enforceable rights and obligations are. Therefore, a stranger should not be saddled with the responsibility. See Rebel Industries Limited versus Magriola and Oz. PENGASSAN are not burdened to this duty. This dispute is not just about one company and its workers. It is bigger. Dangote Refinery is a national asset. It affects fuel supply, power generation, and investor confidence. If PENGASSAN cuts off gas and crude, Nigeria could face fuel scarcity, rising prices, and even electricity problems. That act by PENGASSAN is emboldened by Section 44 of the Trade Union Act to indulge in actions that amount to economic sabotage, rascality, economic terrorism, breach of fundamental rights, and total disregard to the realization of Nigerians' dream for true development. On the other hand, if workers are afraid to unionize, that undermines labor rights and sets a dangerous precedent for how big corporations treat Nigerian workers. So what's the way forward? A balance. Dangote's right to manage its workforce must be respected, but workers' constitutional right to join a union cannot be sacrificed. The courts, the government, and the public will all play a role in how this unfolds. At the end of the day, this case is testing two fundamental principles: corporate freedom versus workers' right. Which side should prevail? Which side should prevail? Or is there a lack of understanding of both concepts? Let me know what you think in the comments.